there's actually two things going on. One is the Federal Trade Commission. So it's actually not legislation. It's their rulemaking authority. So the Federal Trade Commission is as part of their role in promoting competition, or at least this is what what they're saying is the rationale for it. They have put out they've had a draft rule in place that was supposed to be, they have to listen to public comments from industry groups and things. And that was supposed to end last month, but because there were something like 25,000 comments on this, they extended it to, I think it was last week. And so now it's back in the hopper and they're working on it. So there is the rule from the FTC, which would effectively eliminate non-competes in all 50 states if it becomes final. But also over there, sort of down the road, in Congress, there has also been floating around for the last couple sessions a bipartisan bill that would have a sort of a similar effect in making non-competes less enforceable. That seems stuck. Like that seems like that's not going anywhere, at least right now. But both of those things are happening. So really what I want to just focus on today is what the Federal Trade Commission is doing.
Well, the whole thing makes me nervous and uncomfortable. And I imagine makes lots of business owners uncomfortable. Could you handicap this? What's the likelihood that this would actually become an enforceable rule at some point?
Yeah, this is the part where I say, I don't know. I mean, if you do a Google search on this, you will see that 25,000 comments is a lot of comments. So there was the draft rule, and people said what they thought about it. It's sort of interesting because hospitals and the insurance industry trade groups and the U.S. Chamber of Commerce have all said, if this happens, the world is going to end. Everything's going to fall apart. Microsoft and Google and some of the tech companies had said, this is a great idea, we should do this. And so it's an interesting, I guess from a business perspective, maybe it depends on if you're more worried about people stealing your employees or if you're more worried about wanting to steal talent from other people. I guess it sort of depends what side of the fence you're on. But to really answer your question, David, it seems to me that the FTC's rulemaking is, it passes the straight face test that this is within their ability to do. Now, whether that's actually true or not, the courts are going to tell us. But the timeline looks like this. They've got to issue the final rule. And then once they issue the final rule, maybe it's the same as the proposed rule. Maybe it's something different after all those comments. But we'll all have 6 months from then before the rule goes into effect. So we'll have a little bit of time to kind of get our house in order and figure out what we're doing. But, really, does this actually come into effect? I think that there's going to be lots of legal court challenges to it saying the FTC doesn't have the authority to do this. And we're just going to have to wait that out and see.
So is this one of those debates that will eventually land in states deciding they want to do their own thing, or?
No, because that's what states do now, right? So every state has their own non-compete law right now. So, for example, in Texas, over the last, even just since I've been practicing the last 20-something years, non-competes were difficult to enforce in Texas. Because they had some very specific requirements around protecting confidential information and training. And there were a lot of magic words and timing involved with the agreements and things. And then as time has gone on, they've become easier to enforce in Texas. But for example, we have a lot of companies from California coming into Texas. And basically, California has had something very similar to the rule that the FTC is proposing for a long time, where basically non-competes are not enforceable except in very rare situations. And the primary one being if you're selling a business, like if somebody's buying your business from you, a non-compete would be, enforceable in that situation, even under the FTC, if you own 25% of the business or more. I also see Jim popped up a question. Non-solicitation, right? So let me just back up and say what it says. Here's my 10,000 foot version of how I read the FTC regulation. One is employees both not enforceable, non-competes for employees both not enforceable and in violation of the law. So both illegal and not enforceable. So I think if the rule goes into effect and it holds up, it also means having to contact employees and saying, hey, that non-compete that we gave you, just kidding, because we can't have that anymore. So rescinding it and taking it back, right? So that's the big picture. It would allow on the sale of a company, owners owning 25% or more to be bound by a non-compete.
Why? Why is there a carve out for that? That doesn't make any sense to me.
Well, because it's sort of the what are you buying, right? If you're buying a business that you're buying the relationships, customer relationships from an owner, if they're allowed to just, you pay them $4 million and then the next day they can turn around and like call all their customers and take it away again, right? I mean, so there's a carve out for that. Where it gets tricky too, the FTC is so non-solicitation and non-disclosure, right? So non-solicitation, what the rule says in general is, if it looks like a non-compete and it quacks like a non-compete, it's a non-compete, right? So we're going to take a look at what the thing is. But I think narrowly tailored non-solicitation of fellow employees, I think is still going to be possible. That would be my guess. I think that if you say non-solicitation of existing customers, that's in rougher water. And I think that, maybe if it said like with people that you worked with directly for some reasonable period of time, maybe that holds up. This is just sort of my guess now, right? We're going to find out. But that's good. But so non-solicitations are going to be looked at in how does this affect competition? That's going to be the lens. The really scary part to me is the non-disclosure agreement part of it. So this is, the things that we sign that say we're not going to reveal the secrets of my employer to other people. And, the regulation says we're going to allow those, but if they are so broad, we're going to treat, if they're so broad that they restrict competition, we're going to treat them like a non-compete and they could be invalid. So this is, I think this is a big one because we all have these forms out there with our existing non-disclosure agreements, and the judge. I grew up kind of outside Houston, but the judge that I worked for when I first started was a longtime Texas guy, and he loved this phrase, which was pigs get fat and hogs get slaughtered. And so it's sort of one of these things where really I think we're going to have to go back and look at our NDAs and say, all right, is this reasonable? Is it narrowly tailored to protect what we're really trying to protect? Or is it, because if it's so broad, you might be running the risk of not really having a non-disclosure, even if you think you might have one.
I'm still hung up on why there's a nod to purchasers of business so they can be sure what they're getting. As the owner of a business, I'm concerned that the value of my business is going to diminish before I get a chance to sell it to somebody. So if all of this happens, it seems like we're going to have a lot more trouble keeping confidential information and business know-how from walking out the door with employees that leave. How is an owner to protect that information, sometimes very critical information to the business?
I've been spending some time looking at how businesses in California have been dealing with this for the last 20 years. I mean, it's not a perfect alignment, but it's pretty close. And this is what I would say is, I think that problem, the problem of employees walking out with confidential information and walking out with customers, right? I mean, those two problems, we've addressed them with a toolkit of stuff, right? I mean, one has been a non-compete, non-disclosure has been another one, right? Non-solicitation of employees has been another one. And those are all sort of on the, call them the restriction side, right? But on the golden handcuff side, right? You're looking at things like, is there an equity plan or an equity appreciation rights plan that keeps people from wanting to leave in the first place, right? Are financial incentives sort of aligned so that people are, financially incented to stay through maybe a transition or an acquisition, right? And I think, the where I think this is going, like let's say that this FTC regulation stays in place and it happens, right? I think we all really need to start thinking about, yes, non-disclosures, but also just, what information do particular employees have access to? Maybe looking at sort of technical solutions in locking down some of the information that particular employees might have. I mean, so this is not glamorous stuff, right? But this is thinking through, what does it mean? And then also thinking through about, all right, well, how do you hold on to employees, right? I mean, how do you hold on to the good ones? Is there some sort of golden handcuff plan that you can put in place that makes sure they stick around?
Well, okay. I hear the be nice to your employees direction there, but you're also going to have employees that aren't going to work out and that you're going to want to go away. My concern is they take prospect lists, customer lists, pricing information. What do I do about that?
Yeah, I mean, to be clear, I mean, for the people who like actually go and steal stuff, right? I mean, non-disclosure agreements are still going to be, as long as they're not super broad, they're still going to protect that. So in other words, someone signs a non-disclosure that says, I won't steal stuff off of our cloud drive or our server when I leave, that you're still going to be fine with that. And those are going to be enforceable. I think just from seeing my partners, my litigation partners who are in the unhappy end of the hallway, down the hall here, the key there is to actually have the evidence that they've taken it. Like that is really the hard part of it. So again, this kind of gets back to some technical solutions, I think, which is, okay, someone's leaving. Can you see what emails they sent out with what attachments, right? Do you know what they've pulled off of your document repository? Like, can you see, when they've last accessed your, Salesforce? And I know Salesforce and things like that has that, that logging in it. But I just think logging is going to be super important because you can go, if someone goes and steals something, you can go to a court and say, here's the NDA, here's what they took, right? You want to show that this is the log that shows they took it. And then you can ask the court to say, stop them from using this and also give them a cooling off period so they can't work with that person that they took it to for a period of time. So that sort of sounds like a non-compete, right? But it's really a remedy for them taking stuff. So the hard part of this for business owners, though, is often proving that they've taken it.
So my mind goes to situations where former employees have taken work they did while they were employed. This happens all the time in companies like Jessica's, where folks that will design something will want to add it to their portfolio or put it on their website as an example of work they've done. I assume this doesn't take the enforcement possibilities out of agreements that involve ownership of company intellectual property. Yes.
Yeah, that's right. It doesn't affect that. And there's actually two levels there. One, if someone is an employee, so not an independent contractor, but an employee of a company, everything that they do for the company is owned by the company, like from a copyright perspective, right? Or, intellectual property perspective. It's better if you have a document, you have a non-disclosure agreement, or sometimes called proprietary information agreement, that actually specifically says, if you're Jessica, you might want to have a line that says, this is what we own the portfolios, right? Or if you want to let them show it, you can say, we own the portfolios, but you can use it to do X, Y, and Z with, right? If you want to be generous to do that. But so this is what we're talking about from the FTC does not change what we're talking about right now, unless that non-disclosure agreement, also said something like, I don't even know what it would be, but the general knowledge that you learned about the industry is confidential information and you can't use it.
So this is
that, would be, my guess would be something like that would be actually said, oh, well, no, that means you can't compete. And so we're going to treat that like a non-compete.
Okay. So that's a restraint of trade kind of angle. So I take it that, the one that always gets me is when I have to sign a non-disparagement. After I leave a place, I want to disparage them like crazy. And I assume that I'm not off the hook on that with some of this new, these new rules, right?
Yeah, not in the one I'm talking about. There is a whole nother thing happening about non-disparagement clauses that has to do with that is outside of my bailiwick, but it's if you Google non-disparagement and you Google labor relations, you'll find some stuff about that.
Probably David Pearl would come up there too a few times, but
probably that's right.
Yeah. All right, so let's see if I want to open it up for conversation, but aside from the rather general, be nice to your employees so they don't try to rip you off later.
Yeah, no, and so I want to be clear about that. It's not be nice. It's create incentives that they only get the money if they do what you want.
Oh, right? Carrot versus stick.
Yeah, right. I mean, that's right. I mean, so, and particularly the situation that I'm thinking about, that's the hard situation. Well, I spend a lot of my time helping businesses get ready to be sold, right? And so one of the things is, one of the questions in my mind that's been popping up is, okay, so you're getting your company ready to be sold, and you've got your management team, and your management team probably has non-compete agreements in place, probably, in that situation. And, the buyer is coming and saying, well, I want to make sure that I can't make that management team work for me, but I like it that I can keep them from working from your competitors, right? And so this is going to change that negotiation a lot. And so I guess like a good example of the carrot approach is, well, if you can't rely on a non-compete in that situation, there probably needs to be some financial incentive for your management team to stick around with the buyer that's significant enough that they have something to lose if they walk out.
All right. So I know the kind of work you do with companies, and it seems that there are different cases that present themselves in terms of fully understanding and implementing some future rules that cause these to be important. What would you do, practically speaking, with a brand new company you're helping set up? What are the things that you would recommend that company does? And recognize that the next question I'm going to ask you is a much messier one, where you walk into a company that's got 15 years of experience, but a new company. What do you recommend that a client of yours should do in order to minimize the negative impact that a more restrictive rule like this presents?
I would think that to start with, it would be to have an employee non-disclosure agreement, but really spend some time, like, don't just have it be the blah, blah, blah non-disclosure agreement. Like, actually think about, okay, what does this employee have access to? What would be bad if they took and used, right? So more thinking on the NDA than we're used to, right? So in other words, like, really thinking about, what is it that this employee can do? What's the situation? And then tailor it so that, that is what is protected by the non-disclosure agreement. So it's not so broad that you're running at the risk of that it might not be enforceable. Okay, so that would be one piece. I think that sitting here today on April 25th today, I think it's probably worth it to include a non-solicitation of fellow employees. I think that's going to make it through this, but I don't know. But I think that's probably worth trying to do. And then just also sitting down and, new business is just having the conversation about how do you lock up the jewels, right? Where is the stuff that is really important? The customer list, the customer information, the database, whether it's, like Jessica works with HubSpot or Salesforce or whatever, right? How is that set up? And is it locked down on a need to know? And even if people have access to it, is it being tracked? So you can tell when somebody sucks down a bunch of information or whatever out of it.
Okay, so it sounds like if you're building your business from scratch, that you can help yourself out later if you're smart enough, or you find someone who's smart enough to help you put some of these things in place to protect you. Let's go to the far more likely reason that you get a call, I suspect, Paul, which is, okay, this rule is changing. I'm thinking about selling my business someday. I've done a gazillion different things over the last 15, 20 years of my business. I got 150 employees, all with different levels of stuff in the files. What the heck do I do?
So, if this regulation goes into effect and it stands up, I think that one, you're going to have to pull back your existing non-competes is part of what at least the proposed regulation says. So in other words, the existence of the non-compete is a violation of the law. Okay, so that is different than California. All right, and so I think that, given everything that we know right now, I think probably step one is there is some carefully crafted blanket communication that says, just kidding, to the extent that you've got a non-compete, we're pulling it back. If your files are good and you have the agreement with the employee that they signed 15 years ago, you reference it. But if you don't, maybe you put the ones that you have in one pile and you say, here's your attached thing, and I'm pulling out section 3 or whatever, right? If you don't have it, there's probably just a whatever we have, I'm pulling back is probably step one. The hard part for existing businesses is going to be, it's always hard trying to get employees to sign stuff after they've been there a while. Like, even if it's a non-disclosure, like, why do I have to sign this? Don't you trust me? And, all of this. But I think that it's going to depend on what the business is like and what the culture is like. But it seems like if we're pulling back all the NDAs and the non-competes, we're issuing clean documents, there's probably going to have to be I think in a lot of situations, there's probably going to have, it might be a good idea to have some financial incentives to get the people to sign those new documents. So you've got it cleaned up.
Other than you can continue to work here and get paid?
This comes up a lot. But if a really good employee who you care about, like, who you want to sign this because they're a good employee and making you money, are you firing them because they don't sign the NDA? I mean, maybe you should, right? But I mean, it's a harder choice, right?
I don't know if she wants to talk about it, but I remember a specific circumstance with one of the people on this call who happens to be female and the only one other than Joanna on the call who had this very situation occur. And that was the question. What do you do if somebody says, no, I'm not signing that?
I mean, you've got limited choices, right? You can fire that person. I think one thing that I do find that is sometimes helpful is if in a situation like this, you're doing it for everybody all at once, right? So it's like you're saying, oh, there are these changes. You might have heard about this. But I would suggest sometimes it's effective to pitch it as, hey, we're all doing this because, while we're all doing this to protect all of our livelihoods here, right? It's like, you never, individually, I might like it if I don't have an NDA, right? But collectively, if that person in that cube over there takes the stuff and puts me out of a job, I'm mad about it, right? And so, I think there may be, depending on your industry, some explaining about it and saying like, look, this is really to protect the whole company and all of our livelihoods. Sometimes people are receptive to that.
I'm wondering if this is just my experience. I'm guessing it's not, and that this is a common situation for the types of companies that join TAB because they're interested in running their businesses better. It's the early employees that didn't sign anything because we didn't even know if the company was going to turn into anything. And those are also the people that have the information that I'm least willing to be happy about walking out the door. So you're saying you can sort of do a King's X. Sorry, all these are gone. Kind of communication and just no, I guess those are the people that don't have the agreements, so they never had them in the first place. I don't know. This sounds complicated, Paul.
And Jessica's asking how long do we have? And so there's probably three moving pieces to that. One is, when does the final rule get issued? I don't know. I have read some things suggesting that they think we're talking about, a couple of months, but we'll see. Once the rule is issued, we'll have 6 months before it goes into effect. I would be surprised if it's before the end of the year. 3, though, is once the final rule gets issued is when all the lawsuits about the FTC does the FTC have the ability to issue this rule or not will happen. And so, there'll be courts, some courts stopping it in some locations and others probably not. And, I suspect it winds up going, to multiple appeals courts and, maybe even the Supreme Court by the time we get done with this. So
I'd like to pick on a couple of people in the peanut gallery here. Specifically, let's go with Jim Gerberman and Rich Berman. The two of you are both in businesses where you help business owners that are buying or selling buying another company or selling the one that they have. What kinds of feelings does this engender in you and questions that you might have for Paul about value of the businesses that are being bought or sold, and the confidential information that goes along with each of those. Jim, you're unmuted. So
yeah, I'll Paul touched on this a little bit earlier. I don't know that I see this affecting valuation much at all. I can create in my mind an argument where, as you put out before, there's some question as to how well you can protect the value, the assets, and including information or intellectual property. But the law doesn't change, I don't think, Paul. I think you're talking about a rule that provides guidance, but the law is still the law in terms of somebody stealing something and taking something. And, the way valuations are determined is it's a negotiation between a buyer and a seller, and sometimes in the context of other parties as well. So I don't think this is going to have an effect on either the valuation or even how deals get done, honestly.
Paul, what do you think?
Well, right. I mean, because the non-disclosure agreements are not affected as long as they're not too broad, right?
Right.
Mm-hmm. They are going to become. I mean, I think maybe there's going to be some more due diligence in the process on the non-competes, just because the non-disclosures, just because really we were using the non-competes as a tool to protect assets, right? I mean, it's really what we were doing, and it was sort of it's always been kind of a shotgun approach to it. Yeah, but I mean, I agree with you. I mean, I don't think it keeps deals from getting done, unless business owners are ignoring this and, they're relying on a non-compete or something that's too broad, and in due diligence, a buyer looks at it and goes, well, this doesn't work, right? I mean, so it's just, I think it's just like trying to get it cleaned up before you get to that point.
Well, and again, it seems like the handcuffs that a buyer might want to offer up in a golden way might be a way to ensure that they don't just buy a company where all of the key players immediately leave and go compete against the business I just bought.
I guess I'd like to say one other thing. I think that the effect of this won't be that it will eliminate the putting in place of agreements that we've talked about that'll either, whether it's non-compete, non-solicitation, or non-disparagement. I think there will still be agreements that are put in place for that purpose. I don't think that it will eliminate it. And the other thing is, I think anyone who relies simply on the document as guaranteed that something won't happen bad is kind of fooling themselves. The document itself doesn't protect them. It gives you the ability to show that someone who did something bad actually said they wouldn't. So there's a lot of practicality here that I think will be overriding and taking effect as this rolls out.
So, Rich, I borrow a bunch of money from you so I can go buy a business. Does any of this matter to you, or you just want me to pay back my loan?
No, absolutely. I mean, when we finance the acquisition of a company, the last thing we want is for everybody to bleed out and the company tanks immediately because key management doesn't stick around, right? I mean, we want those protections in place and to know that that's likely going to happen. So that
I do pay back my loan.
That would be ideal. Yeah. Starting in month one. But I agree with Jim. I think, at the end of the day, the documentation itself doesn't protect you. I mean, people are going to take stuff when they leave and take knowledge and information and lists. I think that's natural, even with any kind of agreements that you've got in place. But I think it does put more of a focus on being more intentional with those documents, Paul, like you said, on the front end to make sure you're being very specific and not just taking a generic template you found on Google and putting something together. So you're going to have to be more intentional about it. But I'll speak from my firsthand experience. Pioneer Bank did not have a non-compete. No non-compete, no non-solicitation.
Wow.
So coming into the bank, I did not have that. But when Sunflower acquired us, they had a very detailed non-solicitation agreement, non-compete. It put a lot of us on our heels a little bit, because my fear was, you're telling me that if I stay on, that you get to take over all of my customers that are here because of me, and if something happens and I leave, then I've lost the ability to try to go and still earn those relationships back. Or what if I go through conversion with the bank and you fire me and I don't survive the merger? You have the right to keep my book of customers that I brought on, right? So I had a lot of questions about that, a lot of concern. A lot of us did. But at the end of the day, we all ended up moving forward signing. We did have one individual that just flat out refused to sign. And so they told him the deadline for you to sign and return that to us is this day. And he did not. And that was the end of that. They just made it a firm policy and did not negotiate it. And, they probably lost a few people along the way, but they probably got 95% of the employees to do what they wanted, right or wrong. But at the end, I do think most of it's hard to enforce, even prior to these changes that are coming up. You just need to be more intentional about it. The other thing that we do have that we talked about monetary compensation, Paul, on this, and ways to incent people to stay. So one of the things that when I came through the merger with Sunflower, they implemented a deferred compensation program. So part of my compensation that's not my salary, right, bonus money for the year, is like 10% is put into a deferred comp plan that is not vested for 2 years. So that starts building over time. And at any time, if I leave, right, I've got money on the sidelines that is not vested and just goes away. It's something to think about before I leave now, that I've got, a pool of funds that are sitting there that are not vested, and some might be at any given time, but there'll be a chunk that is not. And it's something that I will lose if I were to leave.
Rich, you remind me of a company I was involved with where we sold it, and some of the owners worked for the company, and there was some consideration for agreeing to a non-compete, and it was not a giant sum of money. And in fact, my initial reaction was, I don't need that. I'd rather not have the non-compete. Paul, if you pay somebody if somebody agrees to sign a non-compete in return for extra money, does that somehow take it out of these proposed rules, or that would be illegal?
No, you can't. Hey, Greg, do you have your hand up?
Yeah, he does. I saw that. I was gonna get Greg next.
You can't. Yeah, paying somebody extra to sign one doesn't fix it. No.
Okay, Greg, what's your question?
Yeah, sorry that hand up was so annoying. I just, Paul, when you introduced what the potential ruling was all about, one of the things that you mentioned was that it's really in the spirit of competition. And so when I think of competition, I think about how the consumers or businesses benefit from more competition. I can't seem to connect the dots in my head as to how this opens up things for better competition, other than, potential unethical behavior or something like that. I can't seem to connect those dots. Can you maybe do that for us so I understand where they're coming from?
Yeah, I mean, I can try. I mean, I think that if you want a deeper dive into this what I'm about to say, in there's the rule itself. So if you go on the FTC website, you could read the proposed rule. But before that is sort of, they have to state the rationale for why they think they can do it. And so that's you can look there for the longer version. But here's what I understand. Two things is, one, I think there is the idea that it is better for businesses in the long run and ultimately the consumer if there is free mobility of talent, right? So instead of talent being locked up in silos and can't go and leave to the place that they can make their maximum contribution, if we eliminate this, it allows more freedom of movement of talent. And so that's going to be better for the business community as a whole and ultimately for the consumers. So I think that's one sort of thought swirling around. I mean, the other thought swirling around is I actually think, this is the part where I wonder if the FTC's, I suspect the point of challenge is going to be this, which is the FTC also said, this also impacts the labor market, and their I don't know how they came up with this number, but it is some crazy number, 300. Like if we eliminated this, it would increase wages by I think it's $300 billion, some insane number. I mean, don't quote me on that, but the idea was that basically people don't increase their wages by staying in the same place. They increase their wages when they move usually to another business and they have a different job, right? And so, you know this better than anybody on this call, right? So the idea is, okay, if you eliminate this, it's going to increase wages, and so it's increasing the labor market by removing this restriction. So I think those are the two, why questions.
Thank you.
So we want to encourage business owners to struggle with retention.
Well, we want to encourage business, right? But on the other side, of this, I feel a little, I feel my brain divided about this one, just because I also see people who, there's a lot of stories of people who leave their, including some of the people on this call who leave their bad employer, right? And they go out and they start their own business and they employ other people, and they're employing other people and they're contributing and they're generating wealth for themselves and their families, and right? And the flip side of this is that becomes easier, right?
It has always been interesting to me. I don't know if people know that the legal profession has always had this, this rule. Yeah,
in Texas, for just weird historical reasons, I think lawyers you're not allowed to bind a lawyer to a non-compete, and the thinking is it's because the clients should be able to do whatever they want to do. That was the rationale behind it.
Reggie, I think you may have had your hand up at some point. You still have a question?
My hand's still up, and I still do have a question. And it, but now I'm gonna make a comment before I ask my question. And it's just, we're talking about this in terms of selling your business. I think is the main thrust of how we're thinking about it. But I think about it in terms of both sides, because although I haven't worked for anybody since I can't even remember the last time I worked for somebody, people work for me, and I have to be empathetic to what they're going through. And Texas is a right to work state and has been for many years. And I think the impetus for it being a right to work state is because we are a very conservative state. So it's interesting here because, okay, it's a right to work state. People have the right to quit and go where they want or please. And in doing so, you don't want to hamper somebody from continuing in their chosen field, which is why I don't have a non-compete. They have the right to compete with me and work for somebody else if they feel like somebody else is a better boss than I am, and or if they feel like they could be a better boss than I am. I think that's fair and that's open competition, and I want that because I live in America and I don't want Russia. At the same time, I have a non-solicitation, which basically says, don't take my goddamn clients for a period of time. Not forever. You can, at some point, take my clients. And in reality, I don't think one person on this call feels like just because your insurance agent bought the business and you were agent there, you feel like you should stay. You feel like after, I don't know this agent that just paid $5 million for this agency. He paid more for this agency than I could ever conceive. But now I feel like, you know what, I'm going to shop around because I don't know this guy. That guy probably cares more about you than anybody else ever will. But you know what? They leave, and they may leave and go with the new person or the old person or whatever. And my only thing is you can't go with the old person, or you can't go with anybody that I've hired and trained for 5 years. After that, you do whatever you want. And it also says, and Paul, you can tell me if I'm wrong or not, but it says if they do go with you, you owe me 5 times the loss, 5 times the loss. If I'd have made $10 off of them, you owe me $50. If I'd have made $5,000, well, we're gonna probably go to court because you owe me $25K. And I'm not nice about that one at all. I mean, if it's your mother or your sister that left me, I'm kind of like, you know what, like, I'm not gonna sue somebody because their mom wants to be with them. That's ridiculous. But if it's your best friend, I don't give a damn. Your best friend needs to pay me for 5 years, or whatever. Now, that's my way of when I think non-solicitation. We talked about it in terms of soliciting employees, but I talk about it in terms of soliciting clients. You cannot solicit my clients. Do not stick a thumb drive in my computer and download them. We don't teach them how to do that, but they do it. Every employee has to have access to every single one of my clients. Because when any one of you, David or Paul, calls into my office, you don't want to hear, oh, Reggie's at the office at lunch, I can't help you. You don't want to hear that. Whoever answers the phone except a receptionist, you want them to be able to help you and service you. So my format is pretty open. I probably need to look, according to Paul, if I can document who is accessing what, but I know for a fact if they're accessing farmers directly, then I can't really tell, but I can look into my cloud and some off-record stuff and see if they're accessing that. So I guess my only question to you then, Paul, is do I have a foot to stand on in terms of suing if they take the client and they sign something saying I won't touch your clients for 5 years?
Yeah, so I think this is the hard. I think the non-solicit of clients is the hardest, is the one we know the least about. Okay, I will say this though. I think you should put on your to-do list, if this actually happens and this is coming down, go and talk with your lawyer who drafted that agreement, because just say, hey, just checking in, because even if there's a piece of the agreement that says, oh, here's a non-solicit and it's tailored and maybe it's okay under the new regs, if the rest of it is too broad, the whole thing might not be valid. So I just would say it's probably, if this thing happens, it would be a good time to take that agreement that you use as your template and take it back and have it looked at. Is that fair? I mean, I think tailored non-solicitation, definitely of employees going to work. Of clients, it's tough because I got to say, non-solicitation of clients to me just sounds like a really tailored non-compete, like a really narrow non-compete. And so I don't know. I mean, I'm not saying it makes sense, but I think that's something we got to be worried about.
Well, I mean, it is. I do get with what Reggie's after. I mean, it's one thing to go find new clients; it's another to steal the ones that he worked hard to acquire and service over the years.
Well, but right. Welcome to lawyers' world, right?
Because especially if I just paid you for them, I pay you for them, and then next week you go to that guy, move them, and then that guy pays you for them, and the company charges me back for them. So I'm double negative on the deal, and you're double positive. It's a theft.
Well, this is why, this is exactly why the insurance industry, I forget the name of the trade association, was very strong against this and said look, this is going to be a mess if this happens for our industry. So
how about I haven't heard from Parker or Jessica or Joe or Joanna. Any questions, burning questions that Paul didn't get to? I see Jessica's about to ask one.
Well, I was just going to say the story you were referencing, David, was a graphic designer when we asked her to sign the non-compete, and it took a couple of months back and forth because she got an attorney to review it, which was her aunt, who was like an estate attorney, whatever. But she ended up not signing it, and then she resigned. And my creative director at the time was really mad at me for having this piece of paper that caused him to lose a team member. But it turns out she was working for another agency at night, and that's why she didn't want to sign it. So, it just makes me upset. That situation made me upset because I would hate to think that any full-time employee of mine is working for another agency at the same time as us, even if they're in a different state. But if it's like the same kind of work, then it feels really disloyal and a conflict of interest,
Well, and let me say, this ruling is about working for competitors after you no longer work for somebody. It's not
while they're working, right? So we can still ask them not to.
Yes.
And I think that's okay. Because that's the thing too. I think with creatives, they like to have different side hustles and all this stuff. And really in my mind, I'm thinking if you want to work for competing companies, then you need to just be a contractor, not a full-time.
Is that the next step, Paul? That if this is adopted as rule, it seems like the thoughts that gave rise to it would soon go to, hey, it should be illegal for Jessica to tell her employees that they can't work for somebody else during the hours that don't include the 40 hours that she's paying them for.
I don't know. It's not in this. That seems like that seems like a lot further jump. That's sort of out into there is no state that allows that.
Even California.
Right?
Don't you think that's a direction that you could see it going, particularly with the rise of the gig economy? I understand it wouldn't be gig; it would be a full-time employee doing other stuff that happens to be.
The real, what a business can do if somebody's moonlighting and they don't like it is you could fire that person. That's really the remedy, right, for an employer. And I can't imagine, saying, oh, you're not allowed to fire somebody because they're working for somebody else. I don't.
Even in California.
Even in California, I don't see it.
Well, this conversation sort of raises, I don't even know what I'm about to ask here, but I'm going to try anyway. So the whole idea of governance. So I'm an employer in Texas. I hire somebody in California today, right? And their state law that differs greatly from our state law, right? And then how do you feel like the new regulations are going to affect governance?
Yeah. So this is a complicated one, so I read a statistic too, just to back up one step. So non-competes are generally unenforceable in California. But I read a statistic that said something like 30% of employees in California have signed one anyway, because employers are just doing it. Now, the difference is this FTC regulation would actually make it illegal to have one. So that's a step beyond what California has, right?
Federally, yeah, right.
But Joe, generally, Texas says that if the employee is in Texas, Texas law is going to apply to the non-compete law of that employee. I think California also says, although don't quote me on this, if you've got a California employee, California law is going to apply, even if you have a document that says Texas law or some other law is going to apply. So, it's most of the time, broadly speaking, I think where the employee actually is going to kind of answer this question. But yeah, this FTC regulation, if it survives the court challenges, it'll override the state. It'll override state law on non-competes. Yeah,
that's what I thought. Interesting. Oof.
Let's see. Do we have other questions? I guess I have a question. Paul, are you taking new clients these days?
Yeah. Yes, I am, and I'm not going anywhere. I'm not planning on competing with myself.
Okay. I'm just felt like I needed to ask that. Paul, is there anything that is there a capper you'd like to put on this to try and bring it all together? Or
yeah, I do think. There's this question. We're sitting in this time right now. It's like, well, is this really going to be enforceable or not? Is the regulation really going to survive the court challenges or not? And what I would just say is, so nobody knows the answer to that question, but I do think it's sort of it has posed this interesting question to all of us who are business owners, right? Which is, okay, if this tool is taken away, what happens with their business? Are we actually doing enough to hold on to people? Are our systems strong enough to make sure that there isn't data leaking out the door that we don't have to, So in other words, I think that if we took some time now to do the what if game and thought about and planned what we were doing, I think making those changes probably just makes our businesses stronger, even if at the end of the day, non-compete still winds up being the tool.